afternoon, everybody. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you so much for waiting patiently. While waiting, we would like to share with you a short video from our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, and thank you so much for joining us for today's online talk, which is entitled Cryptocurrency and Anti-Money Laundering Risks, Trends in Malaysia. My name is Caroline Ng. I'm an associate in Mawingkoi & Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawingkoi & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mawingkoi. Our able team today comprises 33 lawyers and a support team of 32. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have actually been organizing monthly lunch talks at our office since about 2013, some of which have also been broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be advised and reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, the details of which will be given at the end of this talk. We have two speakers for our talk today, Ms. Agalya and Ms. Kirthika. Allow me to introduce our speakers. Ms. Kirthika is an associate in our dispute resolution department. She graduated from the University of Leeds and was called to the English bar in 2021. She was then called to the Malaysian bar in 2023, and her areas of practice include strata management, family, citizenship, employment, and criminal defense. Ms. Agalya is a partner in our criminal, civil litigation, family, and matrimonial teams. She graduated in Wales and was admitted to the Malaysian bar in 2014. She's actually involved in advising criminal defense matters, anti-money laundering, corruption charges, customs, and smuggling offences. And her areas of practice include criminal law, general litigation, debt recovery, and constitutional matters. Ms. Kirthika will be speaking on the first two talk points for today, while Ms. Agalya will be speaking on the final two talk points, and then we will be concluding our session today with a short Q&A session. So now I'll pass the floor over to Ms. Kirthika. Thank you.
Thank you, Caroline, for that introduction. So, a very good afternoon to everyone present. Thank you for joining our talk today. As informed by Caroline, I will be addressing the first two talk points for our talk today in relation to the overview of BNM, the Security Commission's and MACC's role in crypto AML, as well as how crypto transactions trigger anti-money laundering red flags. So, before we delve into the role of the Bank Negara Malaysia Securities Commission and MACC's role in crypto AML, I would just like to briefly talk about the current law governing cryptocurrency and AML in relation to in Malaysia. So, given the recent significant traction in Malaysia pertaining to cryptocurrencies, the Malaysian government has essentially recognized that cryptocurrencies are being increasingly used by the general public, and they have taken the necessary steps to address this by developing a regulatory framework. So this would be included under the existing Capital Markets and Services Act 2007, several orders pursuant to the CMSA. So this would be orders enacted as subsidiary legislation under the CMSA, as well as the infamous Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001, which is commonly referred to as AMLA, given that the full title is actually quite a mouthful. And these three main bodies of legislation are actually read together with the Securities Commission's guidelines. So these are guidelines that are issued and renewed relatively regularly by the Securities Commission. So I'll first be addressing the relevant provisions under the CMSA. So broadly speaking, the CMSA regulates the Malaysia's capital markets, including securities and derivatives. So essentially, it forms the basis for overseeing digital assets, which are also classified as securities. And the relevant provisions under the CMSA pertaining to cryptocurrency is pursuant to Section 7 Sub 1, which requires that a person operating a stock market or derivatives to be a recognized market operator or an RMO approved by the SE. And this is then reinforced by Section 34, which then provides that the Commission, in this case the Commission, may register a person as an RMO. And from time to time, they may change or vary, amend, or revoke any of the terms and conditions attached to the registration of the recognized market operator. So the broad provisions under the CMSA are to be read with the orders. Now, I will just very briefly talk about the orders under which were enacted pursuant to the CMSA. With any main legislative body in Malaysia comes the powers to enact subsidiary legislation. And these 2019 and 2025 orders are essentially subsidiary legislation enacted pursuant to the CMSA. Specifically, the 2019 order, which is the Capital Markets and Services, Digital Currency and Digital Token Order 2019, as well as the Capital Markets and Services Prescription of Securities, Digital Currency and Digital Token Amendment Order 2025. Now, what the 2019 order does is it essentially defines digital currency and the digital token, as well as provides that securities law shall apply to both digital currencies and digital tokens. The 2025 order, in comparison, was just enacted to essentially amend the 2019 order in relation to the definition of digital tokens. And I will go more on to that in my next slide. As I mentioned previously, the term digital currency and digital token are defined under the 2019 order. And why this is important is it clearly sets out parameters in relation to the definition of what amounts to a digital currency. So here it's clearly defined as a digital representation of value on a distributed ledger, functioning as a medium of exchange and interchangeable with money. And similarly, digital token is defined as the digital representation on a distributed ledger. So why these definitions are important is because it essentially then allows for these digital currencies and digital tokens to be deemed as securities. So specifically, if you look at Section 3 Sub 1 of the 2019 order, it provides that a digital currency which is traded in a place or facility, and in exchange of the digital currency are regularly made or accepted. And so these essentially provide for situations in which digital currency can be deemed as securities for the purposes of securities laws. So what this order does is it essentially creates a situation whereby digital currencies and digital tokens then allowed to be treated as securities, and then the main provisions pertaining to securities under the CMSA, AMLA, and the other bodies which regulate securities and derivatives can then apply to both digital currencies and digital tokens. So similarly, Section 3 sub 2 provides of the 2019 order defines a digital token and the situations in which the digital token can then be recognized as a security. So this is again important because Section 4 of the 2019 order provides that the provisions of securities laws shall apply to a digital currency and a digital token that are prescribed as securities under this order. So any digital tokens and digital currencies which are prescribed as securities pursuant to the 2019 order are then set to have securities laws, existing security law applied to them. So the AMLA 2001, Malaysia's primary legislation for combating money laundering and terrorism financing. I'm sure that everybody here has heard of AMLA in some form or manner because it's one of the most prevalent pieces of legislation in Malaysia relating to anti-money laundering and anti-terrorism. So it applies to reporting institutions, including those involved in digital currency activities. And Section 7 of AMLA essentially provides MACC's functions, which includes receiving reports on corruptions, investigating suspected offences, and examining practices to reduce this corruption. So essentially, the provision allows and empowers MACC to investigate financial crimes, including those involving cryptocurrencies where corruption is. The next piece body of legislation which applies is, just give me a moment, is the Securities Commission's guidelines. So if you can see here, the actual guideline itself has again a very lengthy title. I think this is fairly common when it comes to money laundering legislation, just to ensure that it governs anti-money laundering essentially. So this legislation essentially was amended in 2024, so fairly recently, and it provides a detailed anti-money laundering and counter finance terrorism framework for reporting institutions in the capital market, including those that handle digital assets. So essentially, the guidelines provide requirement and obligations imposed on reporting institutions in preventing and combating money laundering, terrorism financing, and others, as well as guidance for reporting institutions to comply with the obligations under AMLA and any other pieces of legislation. So what's important here is that a reporting institution that is jointly regulated by both BNM and the SC is required to comply with these guidelines. So even though these guidelines are not actual pieces of legislation, so they are not acts per se, they are still required to be complied with as long as their reporting institutions are regulated by the Bank Negara Malaysia and the Securities Commission. So where there are differing requirements between the BNM guidelines and the Securities Commission guidelines, the most stringent of the requirements shall apply. So assuming that there are any differences between BNM's guidelines and the Securities Commission's guidelines, whichever guideline has a more stringent, strict approach, that will prevail. And importantly, if any reporting institution were to not comply with these guidelines, they will be subject to actions under the AMLA and CMSA Act, as well as any other laws under which these guidelines are subject to. So enforcement actions can be taken by the Securities Commission, again, reporting institutions, including the directors, officers, representatives, and employees for any non-compliance with these guidelines. So what exactly do these guidelines provide? If I were to go into the entire thing, it would take me all day. But brief, Section 6.2 provides a comprehensive list of principles and policies that reporting institutions should adhere to. And Section 6.2E mandates a customer due diligence process by a reporting institution. So given that I have now talked about briefly the guidelines and the legislation applying to cryptocurrencies in Malaysia, I'll now go into BNM, the Security Commission's and MACC's role in crypto AML. So like I mentioned previously, there are three main regulatory bodies that govern crypto transaction in Malaysia. So you have the Securities Commission Malaysia, or the SC, which oversees digital assets classified as securities, BNM, which is the Bank Negara Malaysia, which regulates financial institutions involved in cryptocurrency transactions, and the MACC, which investigates cases where corruption intersects with financial crimes. So if you could see, they each have their own scope and area pertaining to crypto transactions in Malaysia, and they're very distinct in a sense from each other. So the Section 15 of the Securities Commission Malaysia Act 1993, as amended, establishes the SC's functions, including regulating capital market activities, supervising exchanges, and ensuring investor protection. So this empowers the Securities Commissions to oversee DAXs, which is digital asset exchanges, as recognized market operators. So this is what I spoke about earlier, about the requirement to register with the SC as a recognized market operator and to enforce compliance with securities laws, including those relating to digital assets. So the SC's role is, in the sense, more as a watchdog and to ensure that there is actual compliance with the necessary provisions and guidelines. And this is pursuant to Section 377 of the CMSA. So the Section 377 of the CMSA provides that the Commission may issue such guidelines and practice notes as the Commission considers desirable, and they may similarly revoke, vary, revise, or amend such guidelines. So the guidelines that I briefly spoke about earlier are enacted pursuant to Section 377 of the Capital Markets and Services Act 2007. This section essentially empowers the SC to implement guidelines to ensure compliance with these guidelines. So in contrast, BNM, as Malaysia's central bank, oversees financial institutions. So when you think of financial institutions, you would largely think of banks and things like that, but it also governs financial institutions which deal with cryptocurrencies. So this would include financial institutions, payment systems, and digital currency exchanges that are not regulated as RMOs under the CMSA. So there are institutions which are recognized market operators under that CMSA, but there are also institutions which are not. So Bank Negara Malaysia essentially acts as a catch-all, and it essentially oversees all these institutions as well. So its roles derive from many acts, but primarily the Central of Malaysia Act 2009, which essentially shows that there is a very broad mandate for BNM to ensure that there is financial stability and to combat financial crimes. And essentially, BNM is the primary body responsible to ensure that all of these matters are addressed adequately. So Section 5 of the CBMA establishes that BNM and its objectives, including promoting monetary stability and financial stability, which is conducive to economic growth. So these are more broad provisions which ensure that BNM's overall objective and function complies with currency and AML in Malaysia, essentially. So Section 22 empowers BNM to regulate and supervise financial institutions to ensure stability and compliance with law. BNM's powers, as you can see here, is quite broad, and this is deliberately done to ensure that they have wide powers when it comes to ensuring and doing whatever is necessary to ensure that there's monetary stability and financial stability conducive to economic growth. The MACC, on the other hand, is responsible for combating corruption, but this is more so in respect of the investigation portion. So its powers are derived from the MACC Act 2009. Section 7 of the Act provides MACC's functions, including receiving reports on corruption, investigating suspected offences, and examining practices to reduce corruption. So these are all important because if you look at Securities Commission and BNM, their roles are more so in ensuring that there is overall compliance. Whereas the question is then who gets to investigate these crimes? Who gets to look into the reports that are received pertaining to any non-compliances or any money laundering issues when it comes to cryptocurrencies? It's the MACC. Again, the MACC has a wide range of investigative powers pertaining to any activities which are linked to corruption. So this would include money laundering involving cryptocurrencies, where corruption is very often a very big feat. I'll now move on to my second point for today, which is essentially how crypto transactions may trigger AML red flags. So the first obvious situation where a crypto transaction would trigger an AML red flag is when there is an unusually large transaction. So usually when large transactions involve significant sums without clear justification or customer due diligence. So this customer due diligence essentially is usually relating to things like KYC, which is know your customer policies. So I'm very sure that the people watching our talk today are very familiar with KYC policies and your bank contacting you for information regarding to confirm your identity. So those are all important steps taken to ensure that not only is the bank aware and financial institutions aware of who and where the money is going, but also generally in relation to what purpose the money is being transferred for. So if all of this information is not there and there is a large transaction of cryptocurrency flowing in and out, then that's usually going to trigger a red flag within the AML sphere. So the lack of verified source of funds or the recipient identity may raise concerns about money laundering and raise an AMLA flag. Paragraph 25 of the first schedule of the AMLA, so this would be the AMLA Act, designates a digital currency exchanges as reporting institutions. So this is very important because if you as a digital currency exchanger already deemed as a reporting institution, you have responsibilities and duties under the AMLA to ensure that you are AMLA compliant, but also the SC guidelines mandates reporting to the Financial Intelligence and Enforcement Department of Bank Negara for large unexplained transfers. So there's already an existing duty if you are a digital currency exchanger for you to then report any suspicious transaction, which would usually involve unusually large transactions where there's no particulars provided, whether this is in regards to the purpose for which the funds are being transferred, or whether this is in relation to who is receiving the funds. So the paragraph 25 of the first schedule essentially provides activities carried out by any person who is involved in the exchanging of digital currency for money, exchanging money for digital currency, or exchanging one digital currency for another digital currency, whether in the course of carrying out a digital currency exchange business or otherwise, would then fall under this reporting institution requirement. So it's important to note that it's not just limited to digital currency exchanges, because paragraph 25 of the first schedule then says whether it's in the course of carrying out a digital currency exchange business or otherwise. So essentially, if in bringing together all the relevant factors, a reporting institution has reasonable grounds to suspect that the transaction of funds is being utilized for unlawful activity relating to terrorism financing or proliferation financing, these transactions should be reported to FIED, which is the Financial Intelligence and Enforcement Department of Bank Negara Malaysia, via the lodgement of an STR, which is a suspicious transaction report. So this is provided for within the Security Commission's guidelines. So the second big red flag is when there are frequent cross-border transactions or transfers. So when there's a high volume or rapid movement of funds across borders, especially to high-risk jurisdictions. So there are high-risk jurisdictions which are identified on BNM's website, and usually transactions, especially where there are multiple transactions to such high-risk jurisdictions, that would automatically trigger an ML red flag. Section 14 sub 1 of AMLA essentially implies suspicion based on transaction circumstances, which would include frequent cross-border transfers, even if it's deemed unusual. So you don't necessarily have to have concrete proof, as so long as there is some sort of suspicion based on the nature of the transaction, then that would be essentially sufficient for a reporting institution to then file an STR, which is a suspicious transaction report. The third and final big red flag in that sense is the use of unregulated or anonymous wallets. Now, I know that there are quite a few providers which use essentially unregulated or anonymous wallets. So this would include the use of privacy coins or untraceable wallets. So privacy coins are essentially a class of cryptocurrencies that power private anonymous blockchain transactions by obscuring their origin and destination. So essentially, it anonymizes the entire transaction, which in and of itself is a big red flag because essentially financial institutions and BNM and the reporting and the FC would, to a certain sense, want to know where the money is flowing, how the money is flowing, to ensure that there's no money laundering or any sort of other illegal activity going on. So transactions involving wallets not linked to registered digital asset exchanges, or if they lack the KYC verification, are usually a cause for concern. So this KYC verification, like I said earlier, is usually utilized by financial institutions such as banks. So this would be essentially gaining more, it's a set of practices essentially to verify the identity of your customers and to assess the risk that they pose. So is essentially if an individual is deemed high risk, then their financial transactions are more monitored. Whereas if a person is relatively low risk, then only if one of these big red flag transactions occur, then it's likely to then trigger a red flag response from the reporting institution. So Section 7 of the CMSA implies that an operating stock market, including digital asset exchanges without registration as an RMO, is illegal and carries punishment as prescribed under subsection 5, which would flag transactions from unregulated forms. So essentially, indirectly, there seems to be an implication here that if there is a transaction without an RMO, then it's essentially illegal. And this is important because the punishment within subsection 5 is not a small one. It's essentially a person who contravenes section 34 shall on conviction be liable to a fine not exceeding 10 million ringgit or to an imprisonment for a term not exceeding 10 years or to both. So it's not a small amount by any means. It's important to recognize the requirement for registration as an RMO with the Securities Commission, because clearly here there is danger of them falling under the or rather being liable for the punishment under subsection 5. So that concludes my section of this talk for today pertaining to the big red flags pertaining to AMLA in relation to C. I will now hand over to address the remaining two topics for today.
Good afternoon, everyone. Thank you for joining us. I would like to start off by thanking our moderator, Caroline, who is here participating in the talk, spending her evening with us. And I would also like to thank Kirthika, my colleague, for giving us a comprehensive insight on the first two talk points. I would like to continue the talk with the trends and enforcement actions in Malaysia. And we would then look at some case reviews on how the courts have decided on issues relating to cryptocurrency disputes. As Kirthika has said, Malaysia's regulators are rapidly adapting to new crypto-related money laundering risks. And here's what's changing. So right now, we have a stricter KYC for P2P platforms. So P2P is a peer-to-peer transfer. Previously, P2P providers such as HTX, Qcoin, and other major exchanges did not have that much of KYC or regulation to operate in Malaysia, but this has recently changed. In 2024, BNM had issued warnings to unregistered P2Ps or P2P operators and listed these operators in the Financial Consumer Alert List that will have a FCA list, which is basically a guideline to enhance the awareness on entities or schemes which may have been wrongly perceived or represented as being licensed or regulated by Bank Negara Malaysia. So this FCA list is available on Bank Negara Malaysia's website. And if any one of you are investors or basically just traders in crypto, I think it would be a helpful list for you to go and look and see if what you're investing in or what you have put your money on is regulated, or in the event any unlawful activities happen, how you can protect yourself. On top of that, there's increased scrutiny on offshore exchanges. So in Malaysia, we have 4 registered exchanges, and these are known as Luno, MX Global, Synergy Technologies, and Tokenized Technology. So Malaysians using other offshore exchanges like Binance or Qcoin or Bybit, which is already unlicensed in Malaysia, you may face actions such as bank account freezing if any of your money moving in and out are linked to these exchanges. And there's also potentially tax investigation for unreported gains. If you are in the business of trading and your trades have gains on them and you are doing it for the purpose of accumulating these gains, then it's definitely considered trading and it's taxable income. So it is different if you were to put in money for investments and just leave it there for a number of years without realizing your gains. Those will not be considered as taxable income. And these days, there are also AI-powered transaction monitoring. So entities like earlier discussed by BNM and SC, Security Commissions, they are currently adapting and using blockchain analytics tools such as chain analysis to highlight potential red flags like flag mixer services, which is being something like offered by Tornado Cash. So how Tornado Cash works is basically transferring money to a pool and then being able to extract that money out of that pool at a different time. So basically, this is what we would call layering. You're mixing your monies with unknown sources and making it harder for it to be identified as monies that may be proceeds of unlawful activities. There are also currently NFT and DeFi risks, such as wash trading. NFT wash trading is basically inflating the value of an NFT. And that is a new AML concern because we don't know where the valuation comes from and how it gains that kind sort of money. Beyond what was discussed just moments ago, there is a public consultation paper 2025 issued by the Security Commissions. So this was actually consultation paper. It hasn't been set in stone. It's still work in progress. And the consultation paper is basically on the proposed regulatory framework for offering and dealing in tokenized capital market production. The consultation paper basically establishes the following, which I'll explain. Proposed regulatory neutrality, treating tokenized products similar to traditional ones, which are provided for in section 1.3 and 1.4 of the public consultation paper. Just for your information, this public consultation paper is available online on Security Commission's website. It has a comprehensive framework on what the SC proposes to do in moving forward with digital assets as a whole. So a definition of tokenized products as digital representations of securities, derivatives, or unit trust schemes using distributed ledger technology. So this is provided for under section 2.3. And then if you were to look further down, section 2.5A and B, section 2.6 and section 2.7 focuses on digital twin tokens. So basically, a digital twin token is having a similar ledger, one which is on open source and one which is just for compliance and for the regulatory bodies to look after. And then section 3.2 and section 4.1, it requires compliance with existing laws, including the 2019 order, and emphasizes on governance, risk management, and disclosure. So certain examples of regulatory sanctions that we may call it, that these are Security Commission's enforcement actions against unregistered or unlicensed exchanges. In 2021, the SC had actually banned the usage of Binance in Malaysia. This action underscores the Security Commission's commitment to ensuring compliance with AML and Counter Financing Terrorism regulations, as registered RMOs must adhere to the SC guidelines. So registered RMOs, we discussed this earlier, requires registration with SC to be recognized as valid or a legal or a lawful entity providing digital assets trading. So Binance had operated a recognized market without registering as an RMO with the SC pursuant to Section 34 of the CMSA. And accordingly, the SC, when Binance was given the time to comply and register itself, but it failed to do that. So the SC had issued a public reprimand against Binance for continuing to operate illegally in Malaysia, despite being included in the SC's investor alerts list in July 2020. In this regard, the public reprimand was issued against Binance Holdings Limited, which was registered in Cayman Islands. So these are what we would call offshore exchanges. The sanction was also against CEO Zhao Cheng, as well as 3 other Binance entities, namely Binance Digital Limited, registered in the UK, Binance UAB, registered in Lithuania, and Binance Asia Services Private Limited, registered in Singapore. So all the effect of this enforcement action against Binance meant that all 4 Binance entities have been ordered by the SC to disable the Binance website and mobile applications in Malaysia within 14 days of business. This was back in 2021. They were also ordered to immediately cease all media and marketing activities, including circulating, publishing, or sending any advertisements and or other marketing materials via emails or otherwise to specifically Malaysian investors. They immediately restrict Malaysian investors from accessing Binance Telegram group. Following that, most recently in 2024, the SC had taken enforcement actions against Bybit. Bybit Technology Limited, previously known as Bybit Fintech Limited, and its CEO Ben Zhou they were put on the list by SC, and they were also asked to comply by registering with the Security Commissions under the CMSA, but they refused to do that, and therefore similar actions were taken. They continued to operate without registering with SC, and they were both reprimanded and ordered to disable their platforms pursuant to the Section 354, subsection 3 of the CMSA. Following that sanction, the SC had directed Bybit to disable Bybit's website and mobile applications or any other digital application platforms in Malaysia within 14 business days from 11 December 2024. It's fairly new and it just came out last year. Then immediately they were ordered to cease circulating, publishing, or sending any advertisements, whether in social media or otherwise, to Malaysian investors specifically. And they were also immediately terminated Bybit's Telegram support group for Malaysians. So now let's move on to how the courts have interpreted currency-related disputes. Most of these, I will say right off the bat, they are civil cases. So basically, they have implications on the Contract Act 1950, and the court had only decided based on those issues. As we can see here, recently in the case of Sim Kwang Kai, Adrian versus Jonathan Wong, the court addressed a dispute involving cryptocurrency in the form of USDT, which is a token tethered to the US dollar, allegations of misappropriation, and the defendant was also citing potential money laundering and regulatory breaches. This case was basically where the plaintiff was asking for the court to issue a Mareva injunction against Jonathan Wong. He had tried to stop the defendant from dissipating assets within the country. After going through the evidence and everything, the court ultimately found that the threshold to grant Mareva injunction was not met, and then the application was dismissed. I'm not aware if there's an appeal on this matter so far, but if we do receive any information, we will keep you all updated on the progress of this case. And in a separate action, so the previous case was initiated by Adrian Sim Kwang Kai against Jonathan Wong, and the next case that we are going to is basically Jonathan Wong versus Ko Chin Wei and another. So it seems that Jonathan Wong is a regular cryptocurrency trader or someone who regularly uses cryptocurrency as legal tenders. So in this case, it was an issue of someone purchasing Lamborghini and a Ferrari sports car using cryptocurrency. So in this case, the court actually went a step further to say that cryptocurrencies are digital assets. And in Malaysia, cryptocurrencies, although they are not illegal, but they are not legal tender. So what this means is legal tenders are monies that moves through regulatory bodies like banks. Legal tender, usually in Malaysia, we refer to as Malaysian ringgit, or any foreign currencies, which in the crypto world will be called a fiat. Okay, so the first defendant, as a witness for the second defendant, testified that the defendant received payment of cryptocurrency USDT 569,000 plus, being the total price of the Lamborghini and the Ferrari sports car. So as the court found that although it's not illegal, it's still not legal tender, it would still fall under digital currencies. It would still fall under valuable consideration under the Contracts Act 1950, as I mentioned earlier. Contract law in Malaysia does not inquire into the adequacy of consideration. Theoretically, the judge was saying that a bullock cart can be considered an exchange for Lamborghini sports car. We know that's never going to happen, but it's just a hypothetical consideration by the court. It's fundamental rule of freedom of contract subject to the provision Section 25 and Section 31 of the Contracts Act, which render agreements that run afoul of those provisions void. So in this case, the court then made a connection between cryptocurrencies being not legal tender. Would it then fall under the umbrella of AMLA Act? So the court then said, for the purpose of curbing money laundering, the anti-money laundering, the AMLA Act includes digital assets as its definition for proceeds of unlawful activities by defining it as assets of every kind, whether or incorporeal, tangible or intangible, however acquired. So this means that the definition of cryptocurrency assets, digital assets, would fall under the purview of the AMLA Act. The court then also said this. So they said, though the Anti-Money Laundering Order 2017 had designated the operators of digital asset exchanges, it is an inherently formidable task to enforce the law in this area, because such transactions, like crypto transactions, could be conducted online without going through any licensed banks in Malaysia. So basically what this means is, as long as you have internet connection, you have a phone in your hand, or you have a laptop, you can transfer money by cryptocurrency exchanges anytime, any day, without having additional barriers such as secure tech or something coming through the bank. So in this case, there was also a trust deed that was created by the parties. And basically, during the trial of this case, the court found out that the trust deed was created solely for evading income tax. So when it found that parties had admitted during cross-examinations that this trust deed was created to avoid income tax, the question then becomes, will the court lend its hand to either party to enforce a sham agreement? So the court found that the trust deed had an illegal effect of hiding the plaintiff's purchase of the said Lamborghini from the insolvency department, because he was still an undischarged bankrupt in year 2021. So this is adding another layer of complication to this case. Not only he was purchasing something, but he was bankrupt at that time and transacting huge amount of money. So when we were discussing AML triggers earlier, this is what we mean. So you cannot declare yourself to be a bankrupt, or if you are a bankrupt, then you cannot be going on conducting transfers and financial transactions using cryptocurrency to that effect. So in this case, the judge ruled that the trust deed relied on by the plaintiff to support the cause of action ought to be struck down. It was an unenforceable instrument in the court of law. So basically, ladies and gentlemen, what this means is that if you know there is something wrong with your agreement with a defendant or with a potential third party, relying on the court to give you justice will not give you the expected outcome if the court is aware that there is some sort of manipulation, some sort of evasion of legality that has gone on in the transaction itself. So now let's move on to how to protect yourself and your business. So this one is for investors, purely those who are into cryptocurrency for the purpose of investing. Our advice is basically to use licensed exchanges. You should only trade on Security Commission's approved platforms like Luno or Tokenize. But as I mentioned earlier, there were 4 registered exchanges in Malaysia, and this includes Luno, MACC Global, Synergy Technologies, and Tokenize Technology. Why we would suggest you to use these platforms is because they follow local AML rules, anti-money laundering rules, and you have a greater chance at protecting your funds which you put into these exchanges in the unlikely event that something goes wrong. Secondly, you should avoid red flags. Don't use privacy coins such as Monero or Zcash for large transactions. They basically attract a lot of scrutiny, and you should most definitely not accept crypto from unknown sources, because you will never know where the source of these funds are coming from. They could be stolen funds, they could be corrupted funds, they could be funds from proceeds of unlawful activities. And since you have no idea about where they came from, it's just best to not accept any crypto from unknown sources. But I do know this is easier said than done, because you have a wallet and then you have sharing of the wallet, or maybe you might share with someone else and someone else is using that wallet in your name. But again, these are all things that you should avoid. Do not let anyone use your accounts on your behalf. even for a day. Just try to avoid that as much as you can. Thirdly, you should keep records. You should save your wallet addresses, transaction IDs, and exchange statements. And to comply with tax purposes, you are required to declare crypto gains in your annual statement, income statement. But again, as I said, if this is being done for the purpose of purely investing, it will not be realized income and you will not have to declare those incomes. You will just have to declare incomes which you are gaining through trading activities. As for businesses, our advice is to comply with the CMSA. Basically, you have to register with the security commissions. So, digital asset exchanges, initial exchange offering platforms, operators, and custodians must register as recognized market operators. Section 7 then implies the requirement for registration prior to operating. So, it's best if you were to register your business prior to operating instead of operating without knowing what are the legalities behind it and then having to go through the whole sanction process or SC's security commissions investigations and then trying to get yourself registered after that could be a separate problem altogether. Okay. Section 34 of the CMSA allows the security commissions to register electronic facilities as recognized market operators, requiring digital asset exchanges and initial exchange offering platforms and custodians to apply for registration to operate legally. Secondly, as a business involving yourself in the cryptocurrency front, you should be implementing customer due diligence and KYC procedures. So you're conducting thorough customer due diligence. This we might also call enhanced customer due diligence, ECDD, and know your customer checks. These are essential to ensure compliance with all guidelines and regulations. Section 16 of the AMLA Act explicitly requires reporting institutions, including digital currency exchanges, to verify the identity of customers and conduct ongoing due diligence to mitigate money laundering risk. Section 8 of the SC Guidelines on Prevention of Money Laundering, which was discussed by Kirthika earlier, it provides how the CDD is to be conducted thoroughly. The next step is for businesses to adhere to the crypto travel rule. So this crypto travel rule was something that is quite recent. Sorry, not so recent, but 3 years ago. Section 9 of the SC Guidelines on Prevention of Money Laundering and Terrorism Financing introduces the crypto travel rule, which came into effect from 1st of April 2022. So this is a guideline. It's a rule that requires reporting institutions to include originator and beneficiary information in wire transfers of digital assets with no de minimis threshold. So what we mean by no de minimis threshold is basically there will be no guideline or base guideline threshold for you to cross for you to fall under this rule or under the crypto travel rule. So basically under the crypto travel rule, the required information on the originating customer would be the name, account number, or the transaction identifier, including your IC or your passport numbers and your address, your physical address that you're living in. The required information for the beneficiary customer under the crypto travel rule will be name and account number or transaction identifier. So Section 25 of the AMLA designates entities exchanging digital currencies as reporting institutions. And as such, you would need to adhere to the crypto travel rule requirements for transaction information sharing. So sharing the originator and beneficiary information for digital asset is therefore essential to avoid any potential complications. You are also, as business, required to report suspicious transactions. So STRs is what Kirthika was talking about earlier, suspicious transaction reports. You are required to submit it in the event you see any suspicion or you have any suspicion of unlawful activities or terrorism financing. And these STRs are supposed to be filed or reported to the Financial Intelligence and Enforcement Department, FIED, which is a body which is a separate, they're being regulated by Bank Negara Malaysia basically. So the SC does not require STRs to be reported to them, but it should be reported to FIED under the BNM. Then Section 11 of the SC guidelines mandates that reporting of all suspicious transactions, including attempts to FIED, as I mentioned earlier, it's to str@bnm.gov.my, which shows that this is handled by the Bank Negara Malaysia. You should also maintain sufficient records. So Section 19 of the AMLA explicitly requires reporting institutions to maintain records of transactions and customer identification for at least 7 years or longer if related to an ongoing investigation. Further, Section 10 of the SC guidelines on prevention of money laundering reinforces this obligation, specifying that records such as customer identification or transaction details must be retained for a minimum of 7 years to facilitate audits and investigations. So that brings to my final point. As a business operating here, you should conduct audits. If not yearly, at least twice a year, you should audit your company, you should audit the finances or the transactions that goes through your company. And then there should also be provisions for training of your employees to look out for suspicious transactions, to look out for red flags, to look out for triggers, AMLA triggers. And this will greatly help with in the unlikely event of you being dragged to court, you at least have sufficient defense to show that you have done all this. And if anything beyond this happens, it is not within your control to have a hand in that. So that brings us to the end of this talk. I think I will hand it back to Caroline.
Thank you so much, Agalya and Kirthika, for your insights on this topic. We will now go into the Q&A session. We have a question from a participant who has asked, please explain and elaborate on double twin tokens. I will pass that question over to Agalya.
So to specifically answer that the twin token rule, as I mentioned, it's a public consultation paper. So right now they are still in the process of gathering information from either industry players or investors or traders to see how they can better improve these kind of regulations that will also help with our regulatory bodies like BNM and SC having an overview of transactions that happens within the digital realm.
Thank you, Agalya. Our next question is, can Malaysian authorities track anonymous crypto transactions, for example, on Monero? I will pass that question over to Agalya.
Okay, so while Bitcoin and Ethereum transactions are traceable, privacy coins, which I've said in my talk earlier, such as Monero or Zcash, they are harder to detect, but it's not impossible. So I also mentioned that the Malaysian authorities are catching up to the money laundering risk. So MACC's crypto forensic unit uses chain analysis and metadata, such as exchange in KYC to link users. So basically what happens is a governing body like MACC or SC or BNM will have the authority to reach out to exchanges such as Binance or such as Luno to obtain the KYC that is within their system. And this is how they would track the exchange of monies. So this is how I would think it could be detected.
Thank you, Agalya. Our next question is, I am a lawyer. Do I need to report if my client pays me in crypto? I will pass this over to Kirthika.
Pursuant to the Law Act, law firms are identified as a reporting institution. And so because of that, there are a few things you need to do. Firstly, you need to verify the client's identity. So this is a part of the KYC policies that I was talking about earlier. The second thing you need to do is to file the STR report if the crypto source is suspicious. So this is if it's an unknown wallet, if it's PEP linked. And the last thing is to obviously just keep records for 7 years.
Thank you, Kirthika. Our next question is, what is the safest way to invest in crypto without triggering AML alerts? I will also pass that over to Kirthika to answer.
So obviously there is no foolproof way of going about this, but there are a few ways to go about this. So the first would be to use Securities Commission licensed exchanges. So this would be Luno, Tokenize. We're not promoting either of these. It's just one of the few licensed exchanges. Avoid large cash to crypto deposits. So you would then, a suggestion for this would be to split amounts which are greater than 50,000 ringgit. Declare taxes, obviously, because LHDN cross-checks crypto gains with bank inflows. So that's a very big area where people often get caught, and to never use mixers, so like Tornado Cash, because BNM automatically flags.
Thank you, Kirthika. I think we'll do one last question, which is, are NFTs really a money laundering risk and how? I'll pass this question over to Agalya.
Thank you, Caroline. So basically, we were discussing earlier how NFTs and DeFi pose a potential risk. And this is because they can be, if the main purpose behind it is something we would call wash trading and overvaluation scams. So as I mentioned earlier, NFT is like a digital artwork. It has no real value unless a value is attached to it by the community. It's what we call the community in that exchange. So wash trading means a seller inflates an NFT value by selling it to themselves with alternate wallets, because there is no limits on how many wallets or an online wallet that someone can hold. So you can have a wallet under different apps, under different providers, and not all of them would require you to have some sort of KYC. So it is quite possible that you can try to slip under the radar and do this on your own. And secondly, there are illicit proceeds. So there are instances where criminals buy NFT with dirty money, or basically unlawful proceeds, and then they sell them for clean crypto. So if you were to buy something at an overinflated rate and someone else who can show their source of funds, it would mean that they have basically sold that NFT for clean crypto, clean value.
Thank you. I've come to the end of our talk for today. Before we conclude, I just have a few more announcements to make. First of all, I just want to thank our speakers for today, Agalya and Kirthika, once again for the insightful talk, and as well as for answering some of the questions that have been posed. Secondly, if everyone could please fill in the feedback form and tell us what you thought of our talk today. The link to the form will be in the box. Thirdly, please do or follow all of our social media accounts. And lastly, if you would like to speak to one of our lawyers, we offer a complimentary consultation up to 30 minutes over the phone or over video conference. Please fill in the form on our website. The link to this is also posted in our chat box. To all of our guests today, thank you so much for joining us. We hope that you found today's session informative and useful, and we will see you at our next talk. Thanks so much.
Thank you, everyone.
Thank you.